Lordship, item number 3, Lordship, I beg to mention, Lordship, in this matter, Lordship had on the last occasion allowed us to file the written synopsis, Lordship. However, Lordship, I'm praying for 1 week's time to file the written synopsis, Lordship.
You file yours?
No, Lordship, I'm praying for a week's time.
Mr. Learned Counsel for the petitioner has sought for some more time to file the written synopsis. We allow this matter for 1 week.
Hello.
May I please, Your Lordship? Your Lordship, I beg to mention item number 4. I pray for some week time, Your Lordship. The senior counsel is indisposed, Your Lordship.
Who?
The senior counsel is indisposed, Your Lordship. I'm for the petitioner, Your Lordship.
This is just for filing of written argument.
It's listed in hearing, Your Lordship.
It's listed in hearing. Today is fixed for filing of written argument. There is no question of hearing the matter. You're supposed to file. Why?
Sure. I'll seek instructions, Your Lordship.
Necessarily delay in the matter. Time 3. Do it by 16.
Your Lordship.
Mr. Learned Counsel for the petitioner has sought for some more time to file the written argument on pre-meet. This is matter on 16.
Your Lordship.
Ready.
Item number 1.
May it please your lordship. My lord, this is a regular bail. This bail pertains to, my lord, one incident that happened at Langtor village, my lord. Langtor village, where a mother and a child, infant baby, was found in a small water pond, my lord. Pursuant to this, my lord, my client Regent Singh Wajri was arrested, my lord. Now there's been more than 65 days plus, my lord. The investigating officer is yet to ascertain whether it's a case of murder or it's a case of suicide, my lord. The 3 bails were rejected. Now, in the 3 bails rejected, and then at least 3 IO reports were submitted. The bail rejection orders and the IO's reports, my lord, all reiterate the same thing, my lord, which shows no progress in the investigation even after 2 months or 3 months, my lord, or 2 months, my lord. So, my lord, and one very important and other observations, my lord.
Even before you continue.
Yes, my lord.
This case, this is that murder case at
Langtor village, my lord. Yes.
Mother and child, isn't it?
Yes, my lord.
I think I'll not be able to take this matter.
Oh, my lord.
See, the fact being, I had visited their house.
Oh, my
Of
lord.
course, after the death of,
After the incident, my lord.
there might be
My lord. My
issue
lord.
of.
My lord.
No, I will not say. See,
My,
I would not
I quite understand, my
but
lord.
if
Yes, I quite understand, my lord. Yes, my lord.
if it,
Yes. Let it be in the other batch.
this is matter before any other bench except this court.
My lord. Obliged.
Item number 2.
Respondents are required to file an affidavit.
May it please your lordship? Your lordship, I need some more time to file the affidavit.
You're appearing for?
Respondent 1 to 5.
5.
Similar prayer for respondent number 6, Your Lordship.
Respondent 5. Who's respondent?
I'm appearing for 6 private respondents, Your Lordship.
I'm for respondent 1 to 5, your lordship.
1 to 5 is the district council, Lordship.
So many times, I mean, given to you, I mean, so many times you have asked for adjournment.
You have not got the instruction, Your Lordship.
Mr. Counsel for the respondent 1 to 5 has once again sought for some more time to file the counter affidavit on the ground that the necessary instructions have not yet been received. Similarly, Ms. Counsel for the respondent number 6 has also sought for time to file the counter. The same not be objected to by petitioner. Matter is adjourned. This is matter for 2 weeks.
Item number 5.
So this two parties, my lord, the state and one is the Union of India, my lord. Now the state have filed these applications, my lord. What is that?
State?
The state have filed one application raising the maintainability of my writ petition, my lord. So, my lord, it would be proper since they have raised the maintainability. If they, then I will reply to the
See, at this stage, why would you?
admission hearing, my lord.
Admission hearing, Lordship.
Yes, why would you? See, this is a matter of 2019.
Yes, my lord.
Then why would the issue of maintainability be raised at this point of time?
They are,
Lordship,
what they're saying is, my lord, question. The first objection that they've raised is on the. They're saying that this is a res judicata. There's already an order passed by the then Guwahati High Court, my lord, and that has finally raised the issue, my lord. That's one point that where they say that's because we are hit by the principle of res judicata.
That is, see, I'm not on that. See, the point is this. This is a matter of 2019.
Yes, my lord.
Now we are in 2025.
2025, my lord.
Why was this issue not raised at the outset?
My lord, they have raised the issue at the very outset also.
maintainability?
Yes, my lord. But
Not heard.
Yes, but no, it was heard from various benches. It was heard, my lord. And then finally, my lord, order could not be passed somehow, and then finally, my lord, it's before my lord's bench now. So we'll have to rehear it again.
Who is here and who is for the respondents?
Respondents,
I'm playing for the
state,
state, my lord.
state is there. And
You have
We just
filed-
pray for a week's time. In fact, Lordship has raised a very important question. What has it been doing since 2019? I'll make a very quick compilation of the order sheet, my lord, and present before your Lordship just to show the conduct of the petitioner so far. Why is it that this matter has been pending from 2019, and why is it that we've not filed an affidavit? Just to reflect all of that, my lord. It's a week's time.
You have not filed your counter.
No, I filed an affidavit challenging
Except
the maintainability, my lord.
Only on
Lordship,
issue of
only on that. So in fact, your Lordship's the other courts were in fact satisfied with the point that this case is not maintainable on the face of it.
Okay.
So therefore, we filed an affidavit only limiting our challenge to the question of maintainability. So on the merits, we've not filed any affidavit. So if your Lordships grant me just a week's time, I'll make a compilation of the entire order sheet.
I would like to differ. They are taking time. I have no problem. But saying that the other court is satisfied, I think there's nothing on the record. So, my lord, we will not go by that, my lord, because this is a bench, my lord, which is here afresh.
That is beside the point.
My lord, my lord.
You see, opinion may
Yes.
differ.
Yes, yes.
But then the only thing is this. The concern of this court is it has been, taken,
Yes,
it
my lord.
has been dragging for quite some time.
Yes, yes, exactly, my lord.
It's exactly, there must be a reason why the courts have not directed me to file an affidavit from 2019. And what could be the possible reason? I'll make a very quick compilation of the orders, my lord.
Oh, that would not be necessary, Mr. Sen.
Lordship.
We have come to this stage. To turn back the clock means makes no is pointless.
Only to reflect the conduct of the petitioner. That is all, my lord.
That's a different thing. The only thing is, if parties are satisfied that this matter can be decided at this
Yes,
stage.
yes.
As far as maintainability is concerned.
Yes.
then the court will hear that.
Yes, Lord.
But the thing is, my lord, if my lord is satisfied that yes, we we have a case, then they'll have to file their affidavits and so on.
Yes.
So that will, my lord, then another time of my lords will be, I mean the courts will be,
We'll hear the matter today,
my lord.
Mr. Sen.
I may be given just a week's time. Today I'm not entirely prepared on this matter. Just to be sure, or my lord can have it tomorrow as well.
Tomorrow the problem. 1 week.
I'm fine with tomorrow as well.
No,
Tomorrow.
no, you'll be heard on the issue of maintainability.
Yes. That's all. Not tomorrow because I have
The court will not insist on your filing of that
Lord.
compilation.
a week's time then, my lord. A week's time because tomorrow I have 2 criminal appeals, my lord.
Mr. Sen Larji, appearing for the state respondent, has sought for time to be heard in this matter. Primate, list this matter to 1 week.
My lord.
One. Obliged. Highly obliged.
Item number 6.
May it please the Lordship. Lordship, Mr. Paul is currently out of station, and I was instructed if this matter may be taken up subject to your Lordship's convenience.
Your other colleagues are there. If Mrs. Paul is not here,
Lordships, they are currently on legs, your Lordships.
how many of you are there in your chamber? Tell me. In order of seniority, I have maintained, see, all along, you see, it's not that we don't notice, we notice, we know, you see, who is who. We've been appearing, like I said, you see, we're all part of the same faculty. So, we understand that senior counsel may not be available for, one reason or the other. But it's incumbent upon the other colleagues to take up the matter.
Lordship, may
You are
grant
the
some
same
more
chamber.
time, Lordship. Lordship,
I know your condition. I will not insist on you taking up the matter. But you are making your scapegoat. And here the issue of maintainability is to be decided.
Also, on the last date also, Lordship, when the council sought for time, Lordship had expressed its mind that at least on the next date, let's overcome the first hurdle, whether revision or appeal.
Exactly. Miss, the counsel for the petitioner has once again sought for accommodation on account of the indisposition of the learned senior counsel, Mr. K. Paul, who is conducting the matter. This court has noticed that the same reason was cited when the matter was taken up, when this matter was taken up on 2/5/2025. Yes, miss, anything?
Your Lordship, in this matter, I'm stuck on the law part, Your Lordship. So I'm seeking for some time.
You'll be arguing the case.
Your Lordship, I'll be needing some advice with regard to the law part from Mr. Paul. And due to some urgency, Your Lordship, he had to leave for Delhi yesterday. So, Your Lordship, I'm praying that if it may be fixed on Friday, Your Lordship.
I know change now to the order. Miss Leonard Counsel. Appearing for the petitioner has sought for some more time on the ground that she is not prepared to be heard in this, on this matter today. As prayed for, pray aloud. As prayed for, this matter after 1 week. I'll give you 1 week's time to.
Lordship, highly obliged.
Item number 7.
May it please your Lordship. Lordship, this appeal, I had already finished my submissions quite some time back. On the last occasion, my learned senior appearing for the claimants had started his submissions. The Lordship had noticed that there was no paper book on record. So we were instructed to prepare a paper book that has come on record, my Lord. So if Lordship allows, I will obviously be required to refresh Lordship's mind on my 3-4 submissions which I had.
Yes, sir. How many respondents are there?
Three, my Lord. Against 2 and 3, it has already gone ex parte, my Lord, on 30th October last year.
So, number 1 is the claimant.
Claimant.
2, 3, owner, driver.
Owner and driver. It's gone ex parte against them.
Please.
My Lord. My Lord, the first very obvious problem with this judgment can be found, my Lord, at page 69 of the paper book. Page 69, if Lordship kindly looks at para 36, last line, 36. At page 69. Sorry.
Yes.
Para 36, my Lord, just the first line. Yes. OP number 3, New India Assurance Company Limited, is liable to pay the compensation to the claimant of an amount of rupees 13,68,520 along with interest at 9%, so and so, so and so. Now, this amount, my Lord, 13,68,520, if Lordship kindly looks at the claim petition which is there, that is at page 5, my Lord, of the paper book. Rather, page 3, my Lord.
Yes.
Page 3, part of the claim petition, my Lord, column 19, amount of compensation claimed. Amount of compensation claimed, there are pecuniary damages, total 10,68,520. Non-pecuniary damages, total 3 lakhs. If Lordship turns the page, grand total 13,68,520.
Yes.
So, first point is that the exact claimed amount has been awarded. In my experience of MSCT cases, it is very rare that I have asked a claimant asks for X and claimant is paid X itself. Now,
Very often the award is always enhanced.
if not reduced, because claimants have the fact is, my lord, claimants have the habit of asking for the sun and the moon and everything else. They are granted much less than that. So this is one of those unusual cases where the exact claimed amount has been paid. Now, why the exact claimed amount has been paid again can be found at page 69, para 35 of the judgment.
Yes.
Para 35, if I'll read, there is catena of judgments by the Honorable Supreme Court where guidelines have been issued for determining the compensation to be awarded to the aggrieved injured party arising out of motor accident. In the present case, the claimant has made a claim only with respect to the damages incurred by him for the treatment of his minor son. The claimant has not made any claim with regards to the permanent disability or future prospects of his minor son. This court finds that the claim of rupees 13,68,520 by the claimant is fair enough to compensate the damages caused to his injured minor son at the time of the accident. Court then goes on to award that claimed amount. So the basis of awarding the award, the amount that was awarded, is the opinion of the court that the claimed amount is fair enough. My lord, with respect to the learned Imesity Nongpo, the opinion of the court that the claimed amount is fair enough cannot be the basis of a judicial determination. To arrive at an amount, if compensation is to be paid, to arrive at an amount, a process of reasoning has to be undertaken. A process of reasoning that is based on the evidence that has come on record, my lord. To say that the claimed amount appears to be fair enough, therefore I am awarding the claimed amount, my lord, that is not a judicial, with respect, my lord, that is not a judicial approach. So the second problem is that there is no appreciation of evidence, there is no judicial application of judicial mind in the impugned order, my lord. In the impugned judgment, award has been passed, amount has been found to be payable, a certain amount. The basis of that award, the basis of that amount, the basis of the entire adjudication is the personal opinion of the learned member that the amount is fair enough. That cannot be, my lord. That is my second point, my lord. The third point is to be found in this para 35 itself. If lordship looks at maybe the fifth line, it is the observation of the court: the claimant has not made any claim with regards to the permanent disability or future prospects of his minor son. So there is a observation that the claimant has not claimed any amount for permanent disability. Then the court goes on to award the entire claimed amount, my lord. My lord, whether or not the claimant has made a claim for permanent disability is to be found again at page 3 from the claim petition itself.
Yes.
If lordship sees the same column 19, pecuniary damages, medical expenses, 2 lakh something, other expenses during treatment, etc., 46,000, other expenses after releasing from hospital, 9,000 something, loss of expected future income on account of permanent disablement, 5 lakhs. So there is a claim. There is a claim for permanent disability. MSCT for some reason was of the opinion that there is no claim for permanent disability and I am awarding whatever you have claimed. But having observed that there is no claim for permanent disability and the evidence will show there is no evidence also for permanent disability, you have gone on to award 5 lakhs for permanent disability. Now, as far as the issue of permanent disability is concerned, whether or not in a particular case a victim has suffered permanent disability, in this case the minor son of the claimant had an injury to his arm, whether or not that injury was of the nature of a permanent disability is to be determined by 2 things: the presence of a disability certificate and number 2, the medical evidence on record. The fact of the matter is undisputed, there is no disability certificate. No disability certificate has been put on record to show the extent of the disability of the minor son of the claimant. So therefore, we are left with the medical evidence. What has the doctor said? Has the doctor said anything about permanent disability? Doctor's evidence, my lord, can be found at page 29.
Yes.
A fairly short statements. Well, I'll read very quickly, my lord. At present, I am posted at so and so. In 2013, I was posted at as MNHO at Bernihard PHC, and on so and so PM, the police personnel from Bernihard Police Outpost bought 2 boys for their medical examination, and they are Mr. Ronaldo Nongrum, who is the son of the claimant, 13 years old, and Shri so and so, 26 years old. Mr. Ronaldo Nongrum was bought conscious and oriented and had crushed injury of his right arm and forearm. Since the injury was grievous in nature, I'll request Lordship to kindly notice the word used, grievous in nature. The patient was referred to higher center at Guwahati for management. Necessary first aid was given to Mr. So-and-so, and he was immediately taken to Guwahati. Shri Kharbor Lintra was conscious. This is the other victim, but we are not concerned because there's no claim from the other victim, my lord. Para 6. I have prepared the medical legal report in one report by my own hand on the same day, that is 13/5 so and so. On being shown, I identify the medical legal report dated so and so, prepared by me, and my signature thereon is the one at paper mark 6, and my signature thereon is paper mark 6/1. This paper mark 6/1, the medical legal report prepared by the doctor, is also present, my lord. That is at page 34, my lord. I apologize, 33.
Yes.
That is paper mark 6. Handwriting is a doctor's handwriting, so Lordship may kindly indulge. I'll read the main portion. Sir, I am submitting herewith the medical report.
Page 34.
33, my lord, 33. Good.
Where's the type copy?
33A,
Huh? Where is it? Get up and show me. It is 33. Thank you. 33, my lord.
33.
33, my lord. 33. The handwriting is a little challenging, my lord. I'll read, my lord. The main portion. Sir, I am submitting here.
33A is not the type copy.
Lordship, unfortunately, for some reason, my copy doesn't have 33A. But if Lordship allows me to read it,
Okay, okay.
Lordship.
Because I can't read it.
Yes, my lord. It's challenging.
For this.
Yes, my lord. But I'll attempt to read, my lord. I am submitting herewith the medical report on examination of the below noted persons as follows. Date and time of examination 13/5 so and so at so and so. Shri Ronaldo Nongrum, son of the claimant. Son of Shri so and so. Addresses there. Observations. Conscious, oriented, has not consumed alcohol. Injury, crush injury of right arm and I can't read this.
Forearm.
And forearm injury is grievous in nature. Number 2, Shri so and so, the other victim, my lord. So again, the only medical evidence is that the injury was grievous. The injury to the arm was grievous. Now, again, with respect to the doctor, grievous would not, possibly was not the correct word to use, because grievous indicates a fatal injury, which has led to death. So grievous, again, with respect, maybe was not the correct word, a serious injury, maybe. But was that serious injury of a nature that amounted to permanent disablement for which the claim has been raised? There is no medical evidence. Neither in the statement of the doctor nor in paper mark 6, which is the medical legal report prepared by that doctor. So the sum total of this is that as far as disability is concerned, there is no medical evidence. In the absence of medical evidence regarding disability, it was not possible on the part of the MACT to first observe there is no claim for disability, permanent disability, and then to go and award an amount for permanent disability.
Mr. General,
my lord.
I think there's some, the opinion of the doctor is that he is to be sent to
So and so.
so maybe he has been sent to Guwahati.
There's no evidence for that. I don't know. Because the opinion was that you please refer him to some.
That medical report would have been,
Would have been the proper,
relevant.
would have been the more relevant and more instructive document, but that has not come on record, my lord. The claimant has not examined or bothered to call Guwahati doctor. So we are left with what we have. What we have, my lord, is a statement of the doctor saying injury was grievous, serious in other words, maybe, but was it a permanent disability? No statement is there. The document, the medical legal report, again says a serious injury, grievous, but again, no whisper about a permanent disability. So going by the evidence on record, which we have to go by, that is the only yardstick available, there is nothing to show that the injury was grievous in nature, was of a nature amounting to permanent disability. So the amount of 5 lakhs which has been awarded by the court, after observing that there is no claim, she goes on to award the 5 lakhs. That amount of 5 lakhs, my lord, with respect has to go because there is no evidence for that. Connected to that, if lordship kindly goes back to page 3 of the paper book.
Yes.
If lordship sees D, which I've just read, loss of expected future income on account of permanent disablement, 5 lakhs, I'm confident I have managed to show that there is no basis, there is no evidence to back up this amount. That has to go. E, next one, cost of permanent full-time attendant kept for overall looking after the victim. So if there was a permanent disability, then the victim was maybe bedridden, for example, then a permanent full-time attendant would be required, for which the cost would have been justified. But if there is no permanent disability, or if there is no evidence regarding medical evidence regarding permanent disability, then there is no question of a full-time attendant also. So I would humbly submit that this claim at serial number E, 2,16,000 for permanent full-time attendance because of the permanent disability, that also naturally, consequentially has to go, my lord. So these two amounts, in my respectful submission, are not backed up by the evidence on record. There is evidence, or there is a statement from the claimant himself that my son has suffered permanent disability. With respect, even though the claimant is the father, his statement will not be enough for a court to come to the conclusion, a judicial conclusion, that yes, indeed, permanent disability has been suffered. On the contrary, the victim himself, if his statement is kindly looked at page 1 minute, just a minute, page 22, my lord. Just one line at page 22, the second last line, my lord. Presently, I am not undergoing any treatment and I am attending school regularly. So this is the statement of the victim himself, a few years after the accident, no doubt, but victim himself says, I am attending school regularly. So again, if I'm allowed to humbly sum up this issue, first the court says no claim for permanent disability has been raised, where in fact there has been a claim for permanent disability raised, which has been awarded by the court. Court could have awarded the claim of 5 lakhs and 2 lakhs something if there was medical evidence about permanent disability, if a doctor had whispered in the witness box that yes, it is a permanent disability. No such evidence is there, no such statement, no such document exists on record. Therefore, the inevitable conclusion is that 5 lakhs plus 2,16,000 has to be foregone, has to be kept aside while calculating the compensation, my lord. That is my third point. My fourth point is regarding another head of compensation, that is at page 3 itself, under non-pecuniary damages.
Yes.
Under non-pecuniary damages, there is an amount claimed for pain and suffering, 2 lakhs.
Yes.
That has been awarded. I am not disputing that. Another claim under non-pecuniary, claim B, loss of amenities of life. 1 lakh has been claimed.
Yes.
I am disputing this. Why I am disputing this is to be found, Lordship, I had also filed a written synopsis. If Lordship kindly looks at that synopsis.
Yes.
My Lord. Para 4.7 of the synopsis, that is at page 7 of the synopsis.
Yes.
Now, in this para 4.7, and previously in my first round of oral hearing, I had submitted a judgment, that is a 2011 Supreme Court judgment, Raj Kumar versus Ajay Kumar, which I have extracted at page 7.
Yes.
Now, this judgment, my lord, is important because this judgment has set out the various heads under which claims can be raised or not be raised in an injury case, my lord. If I'm allowed to quickly read what Supreme Court has said, I'll read the extracted portion, my lord, from page 7 itself.
Please.
Page 7, para 6. The heads under which compensation is awarded in personal injury cases are the following: pecuniary damages, special damages, expenses relating to so and so, so and so, so and so. I am not going through all this. Subclause 4, my lord.
Yes.
Damages for pain, suffering, and trauma as a consequence of the injuries. So this can be awarded. They have claimed 2 lakhs. It has been awarded. So I cannot. Subclause 4, 6(4). Small 4,
yes.
Small Roman 4, damages
yes.
for pain, suffering, and trauma as a consequence of the injuries. They have claimed 2 lakhs for that. They have been awarded 2 lakhs for that. I am not disputing. I cannot dispute that amount. Number 5, loss of amenities and or loss of prospect of marriage. They have claimed 1 lakh for this. Next paragraph, if Lordship sees. In routine personal injury cases, compensation will be awarded only under heads small 1, small 2a, and 4. 4 includes damages for pain and suffering. It is only in serious cases of injury, this is important, my lord, where there is specific medical evidence corroborating the evidence of the claimant that compensation will be granted under any of the heads 2b, 3, 5, and 6. 5, Lordship will see, is the loss of amenities which they wanted 1 lakh for. So only in serious cases where there is specific medical evidence corroborating the evidence of the claimant, only in those cases loss of amenities of life can be awarded. So that 1 lakh which was claimed and the 1 lakh which was awarded is not supported by specific medical evidence, is not corroborated by specific medical evidence. If that is the case, then loss of amenities, the amount that is claimed, cannot be awarded. So I would say that the other deduction that has to be made from the awarded amount is this loss of amenities 1 lakh. So just to, again, if I'm permitted to sum up, the deductions are 5 lakhs for permanent disability, 2,16,000 for permanent attendant because of the permanent disability, and 1 lakh, my lord, for loss of amenities of life. On the quantum, my last request to this honorable court is to kindly notice that the awarded amount carries an interest of 9%.
So see, let's be clear about this.
Yes, madam. Yes, madam.
Out of the total,
yes, madam,
the award is
13 lakh 68,520.
13 lakhs
520. Yes, ma'am.
So you are disputing 5 lakhs?
No, I'm 5 lakhs for disability.
Yeah, just without the.
Yes, madam. 5 lakhs for permanent disability.
5 lakhs. Then
2,16,000 for permanent attendant because of the permanent disability.
And 1 lakh.
And 1 lakh.
So that comes to
8,16,000.
8,16,000.
8,16,000. 5 plus yes, 5 plus 2 plus 1.
Okay. So if you minus this 8 lakhs from 13,
Yes, my lord.
the balance you are not
Disputing.
disputing. That would come to
Approximately 5,52,520.
5 lakhs
52,520.
520.
Yes, madam.
Interest
Has been given at 9%. Here, my lord, I will humbly draw lordship's attention to my synopsis. Para 4.2. That is at page 4.
Yes.
Lordship, at 4.2, I have taken the liberty of extracting Lordship's own judgment, subsequently followed in other judgments also. This was in the case of New India versus Khen Kharsati, 2021 judgment.
Yes.
Now, in this judgment, Khen Kharsati, I had attempted to convince my lord, based on Supreme Court judgments, etc., that 9%, etc., should not be the norm. The norm should be 6%, which is the rate of interest paid by banks, my lord, on FDs, on fixed deposits. If I'm allowed to extract the underlying portion, my lord, at page 4,
Yes.
I'll read, my lord. This court, having considered the authority cited by the learned counsel, that is the case of Srimati so and so, in which this court, while order dated so and so, in MAC appeal number so and so, while dealing with the issue of interest in the said case, relying on relevant judgments of the Honorable Supreme Court, has allowed the interest at 6% instead of 9% per annum to be awarded on the award of compensation given. This being the case, this instant case being similarly situated as far as the issue of interest is concerned, this court is inclined to confine the rate of interest here into 6% per annum. So, Lordship has relied on Lordship's previous judgment to hold that on account of the law laid down by the Supreme Court, etc., the rate of interest should be 6%, my lord. We are seeking the same treatment in this present case also. This present case is similarly situated as far as interest part is concerned. Next page, my lord, just on the off chance that Lordship is inclined to go away from Lordship's previous approach. With respect, my lord, I have quoted the concept of stare decisis. Lordship may kindly stand by Lordship's earlier decision.
Of course, that is true.
Yes,
but you see, as far as issue of interest is concerned,
yes, madam,
it's a flexible issue.
True, madam.
In the sense that you have to go by the present rate.
Yes.
It might be 5, it might be 7.
Yeah. So just on that point, my lord, no bank is offering more than 5.75. 5.75 is offered to senior citizens, whereas the norm is 5.25 to 5.5.
And interest is always a simple interest.
Simple interest, my lord. Simple interest. It has to be simple interest, my lord. So Lordship was very correct. I would humbly submit Lordship was very correct in reducing 9% to 6% in the previous two judgments. This judgment also, the same approach may kindly be adopted. That is my last submission on the quantum part. So as far as quantum is concerned, there has to be certain deductions conducted, plus the rate of interest may kindly be reduced from 9% to 6%, my lord. That is the quantum part. I'll quickly cover my other leg of submissions, which is the fact that the license in this case of the driver was a fake license. And this has come on evidence through, record through evidence of our witness. If Lordship kindly looks at page 31 of the paper book. Prior to that, page 34, my lord, there is a police report. Page 34, there is a police report.
Yes.
If Lordship kindly sees item 7, name and address of the driver with driving license number. That driving license number, my lord, is mentioned.
Yes.
Driving license number so and so, NL05 so and so, so and so, so and so. Now, this driving license.
Page 34.
34, my lord, is a police report. 34. Item 7, serial number 7, name and address of driver with driving license number. Driving license number is mentioned. NL05 2010 so and so. Now this driving license,
7, only the name is given.
name and license number is also there, my lord.
No.
If lordship is
Page 34, serial 7.
yes, my lord. Shri Khabor Tinkan, son of so and so, village Trishang so and so, police station Joai, West Jayanti Hills.
Oh, this is the license. NL05.
NL05 2010 0086. That is the license number, my lord.
How do we know it's a license?
License number. It's NL, not ML, my lord. NL05 20 so and so. Long number is there, my lord. Because this is the column for driving license number. Now this
Where is the exhibit of this?
This is my lord, exhibit 2, my lord.
Page?
1 minute, my lord. This has come through the IO's evidence. If I can just take a minute, my lord. Exhibit 1 actually, my lord, not 2. Exhibit 1, IO has produced this.
Page?
Just a minute, my lord. Page 24, my lord. 24 of the paper book. Page 24, second paragraph. Exhibit 1 is the report of motor accident under should be section 150 so and so of the MV Act. Exhibit 1 by 1 is my signature.
This one.
Yes, ma'am.
Exhibit 1 is the report.
Report of motor accident under order 151 and 2 of under section 6 of MV Act 88. Exhibit 1 by 1 is my signature on exhibit 1.
Where does he say that the license is?
No, he doesn't say, my lord. He doesn't say. He has not investigated. He has only recorded the license number.
That's what he said.
That's all. Now, what I'm driving at, my lord, is that this license, under this license number, was investigated by our investigator, who came as OPW1. So, OPW1, my lord, statement can be found at page 31. Page 31, OPW1, Muhammad Mahiruddin. If I'm allowed to read his statement, para 1, my lord.
Yes.
Para 1, I am working as the investigator under New India Assurance Company Limited since 2003, and I am the investigator in connection with the instant case. I have investigated the driving license number NL05, the same number given in Exhibit 1, purportedly issued by the Office of the DTO, Wokha, Nagaland, and sought for report through RTI application, and I received a report from the Office of the DTO officer by their letter number so-and-so, dated Wokha, 24th January 2017, and as per report, the said license was found to be fake and not issued from the Office of the DTO officer, Wokha, Nagaland. Cross-examination by Shri so-and-so, learned counsel for the claimant. There is nothing much in the cross, my lord. My role as an investigator in the instant case is only in respect of verifying the DL of the driver. I have no knowledge regarding the accident, and I do not know what type of vehicle were involved in the accident. I also do not know who was driving the vehicle, and though I wrote the name of the driver in my RTI application, but I cannot recall his name at present. Copy of the driving license was not given to me prior to my investigation, and only the name of the driver and the driving license number was furnished to me. I was also supplied with a copy of the Form 54 by the Insurance Office. I filed the RTI application addressed to Public Information Officer, Office of the DTO, Wokha, Nagaland. I have not bought copy of the said application before this court today.
So even this letter of the DTO Nagaland was not, exhibited?
It appears not to have been, my lord. It appears not to have been.
How do we test its authenticity?
My lord, the fact of the matter is that naturally the court in Nongpo would have required that letter in the court, yes, when he was making a statement about this letter. Now the fact that it was not exhibited, I cannot run away from that. The record is there. But My point, my lord, is a very humble point, that he has made a statement on oath which has not been challenged also. Which has not been challenged. He has said, I have written to the DTO. DTO has, and he's very specific. Letter number is there, date is there. Which letter issued by DTO states that the license in question, bearing number so and so.
See, he was not even in possession of the copy of the driving license.
No, yes, my lord, he was not in possession. What he says was
and he said the basis of his investigation was only on the number.
Was on the number, because what he said very clearly, he admits that he sent an RTI application, and this is how these investigators, they conduct their investigation, because it's difficult to go to Wokha, Nagaland only for this purpose. So RTI applications are sent, RTI applications are replied to. In this case, RTI application was sent containing the name of the driver and the driving license number. Reply was received from Wokha DTO that this license has not been issued by us. So I would submit that the evidence on record is clear to the effect that the DL in question was a fake DL, my lord.
Maybe, but not. I don't think it's sufficient. It's not see, to come to the conclusion that it is fake one or not.
Very well, my lord. I'll satisfy on that point. Unfortunately, I'm not carrying a judgment of 2018, Pappu versus State of UP. What that judgment says, and 2018, this was a very important judgment, because the tendency on the part of parties in MSCT cases, owners and drivers, is to leave everything to the insurance company. They hardly ever contest these cases, saying that insurance company is the insurance company will take care. In 2018, Supreme Court made it very clear that you cannot make an insurance company liable only on the basis of an insurance policy. Insurance company can take defense that your license was not valid, it was fake, etc. But prior to that, it is the duty of the owner to produce his vehicular documents and to prove that his driver held a valid driving license. If there is a failure on the part of the owner to so produce, then just on the basis of the policy, you cannot say insurance company has to take care of the liability. Owner will be held liable, insurance company will be absolved of liability. Problem is, my lord, I am not carrying the judgment today, but the law in this respect is very clear. So if lordship is of the view that this evidence on record, because of the fact that the letter from Wokha DTO was not placed on record, etc., if lordship is of the view that it is not maybe sufficient, I bow down to that, my lord. But
be that as it may,
yes.
As far as the initial liability is concerned,
yes, my lord.
You are not resisting that.
My lord, I am only seeking pay and recover, my lord.
Pay and recover.
Yes, my lord. Because if I'm pushed to the wall and I'm told that this is not sufficient for that pay and recovery, then my lord, I will have to bank on that 2018 judgment, which says first owner has to come and prove, and then only then the insurance company can be held liable on the basis of a policy. Merely by waiving a policy is not enough, or by stating that there is a policy on record, it is not enough to make the insurance company liable. So at the moment, my lord, I am not on that point. I am not trying to run away from the complete liability.
But the fact remains, you see.
Yes, madam.
You
yes, madam.
You write something on a paper.
Yes, madam.
This is the number.
Yes, madam.
And the authority says this is a fake.
Yes, madam. Yes,
madam. On what basis? They must have some basis.
The authority, madam.
The authority, the Nagaland DTO.
Yes, my lord.
You should have said this is fake because of so.
My lord. What the OPW1's evidence states in para 2, he refers to the letter of DTO Wokha, and as per report, means the letter of Wokha, the said license was found to be fake and not issued from the office of DTO Wokha Nagaland. So DTO Wokha would have, it is presumed that he would have examined his DL register. Having examined his DL register, he found that this number was not present. There was no issued DL issued under this number to this particular driver by this DTO. So based on that, he has given a simple report that we have not issued this license. So that being the case, my lord, I would submit that the fact of DL being invalid, of DL being fake, is fairly proved, my lord. That being the case, again, as I said, I am only seeking a direction for pay and recovery, my lord. That direction was not, unfortunately, granted by the learned MSCT. That direction is all I'm seeking. I'll take the responsibility. I'll take the liability on myself, but I need to be able to be in a position to recover that from the owner. If Lordship grants me that liberty, it'll be a Pyrrhic victory for me, because fact of the matter is, in the last 20 years, I know of one case where we've managed to recover anything. So we'll try and recover, but whether we recover or not, that is a separate issue.
Only if the concerned vehicle is still plying.
Is still plying, which is also in doubt. Whether we can issue notice for us. The starting point is issuance of notice. We face difficulty there only. In the MSCT, it went ex parte. Before this honorable court, notice was issued. He never bothered to appear. It went ex parte. Whether he will respond to the execution notice, there are serious doubts on that. But that will be our headache, my lord. That will be our headache. That will be our cross to bear. For the moment, if Lordship allows for pay and recovery, we will be more than satisfied. On the off chance that Lordship is still holding on to the view that this is not enough to hold that DL was a fake deal, then my lord will kindly allow me 1 day's time. Tomorrow I'll produce that 2018 Pappu judgment which says that only policy is not enough. Owner has to come and prove. If he does not come and prove, then insurance company is released from liability. The burden on the claimant will be then to recover the awarded amount from the owner, and that will be I will have to admit, that will be a difficult burden. Give us the burden, my lord. Give us the burden. Allow us to make the payment and recover it from the owner, my lord. That is my last point. So my points are simple, my lord. As far as the quantum is concerned, certain deductions has to be made. Plus interest may kindly be reduced from 9% to 6%. Second point is, whatever is the amount that Lordship finally holds as payable, we will take up that liability, but we may kindly be granted the liberty to pay the amount and to recover the amount, my lord. That's all.
Please, your Lordship. Last time I have submitted, my lord, started with my submission, but my learned friend changed the submission level. My lord, here it has been pointed out that about the permanent disability, the amount of rupees 5 lakh,
Yes.
award of rupees 5 lakh. Firstly, my lord.
Yes.
My lord, this record we have in the record as per my learned friend also submitted the doctor's finding reports that grievous injury. No, my lord, grievous injury, my lord, court also has observed the injury. A tribunal also observed injury, my lord, and then passed the order. In this particular circumstances, there was no cross-examination in regard to the production of the disability certificate. I may be allowed to read the positions, my lord. This PW1 is the father who has stated that.
Which?
Page 11.
Page 11.
11 is the father and examination in chief.
Yes.
Here in paragraph 5, page 12, in the chief is stated that my son, Sri Ronaldo Nagrum, was with his friend riding a bicycle on the left side of the road. That is on other side of the road following the traffic rules. The offending vehicle came in a rash and negligent manner and dashed the bicycle from the backside, as a result of which my son fell down and offending truck ran over the right hand of my son. The accident was caused due to rash and negligence. Now, paragraph 9.
Yes.
Due to the said accident, there was fracture with displacement in proximal part of radius and ulnar and in lower end of humerus in the view with a derangement of the elbow joint alignment. Injured hand of the victim had to be operated and flesh had to be transplanted from This is the situation. This was. Now, in this regard, cross-examination is in page page 15. I think there is no type copy. It's handwritten ballot of the tribunal. The accident took place on 13th May 2013 at Bernier GS Road. I do not exactly remember the age of my son at the time of accident, but he was in class 6 in the year 2013. My son was a pedestrian, but he was riding on a bicycle with a friend and he was sitting behind. The bicycle belonged to my son. My son's friend was also a similar age like him. I have bought the bicycle 1 year prior to the accident. How his friend knew how to write.
Go to the relevant portion as far as
No, really,
injury
this whole
concerned.
my contention is this, my lord, that the question of permanent injury or disablement, in the cross-examination, there is no whisper. It has not been challenged. That is my submission, my lord. That point was not raised or contested. Even in the deposition of Ronaldo, who has submitted that he got his fracture on his hand.
Yes.
But that question of the certificate or anything, my lord, was not raised.
Yes.
And doctor, in doctor's submission, what my friend also submitted, has opined that it's a grievous injury. Now, my lord, the tribunal is just in giving the compensation in regard to the grievous injury.
Grievous and permanent disability are two different terms altogether.
No, my lord. After the accident, the victim was unable to go to the school for 2 years. So, my lord, that and thereafter in the evidence after in the year 2018, the deposition was given by the victim, who stated that he is not going for any treatment, but his hand was
left hand or right hand?
Right hand. Right hand was crushed. He could not even till now. My lord, is my personal thing. Till now, he cannot use to write anything by his hand. Now, in regard to the certificates, they could not obtain the certificate from the Guwahati. This certificate. That is my position. I am submitting. It is based on the entire judgment was passed by the tribunal based on the doctor's deposition and the report and the claimants and the victim's deposition that he was suffering from this. So my submission is that awarding 5 lakh, considering this submission without having any challenging that permanent disability at this stage of the tribunal trial cannot be considered, and the award passed by the tribunal may be considered as fair and just. Now, my lord, my learned friend had submitted that attendant, my lord, in the page 3. Page 3, my lord, it is for the 36 months only. It is not the permanent attendant. He was suffering from the injuries. He was in the hospital. He was in under medication and he was in a critical state. That is specifically mentioned at the rate of 6,000 per month for 36 months. It's not a permanent cost of attendant. It's not permanent cost. As such, the amount which has been awarded at 2,16,000 for 36 months at the rate of 6,000 per month is just enough, just and considerable, my lord.
Where is the evidence as far as attendance is concerned?
Well, it is.
Claimant, what did he say?
It is by the father of the claimant.
No, yes, that's what. The father, what did he say? He said, I have appointed so and so as my attendant, as the attendant for my son, paid him so and so.
Yes, it's there, my lord. I'm just.
Well, he said something in at para 12, page 13.
In paragraph 6, yes.
Para 12, you look at 12D.
12D, yes. Cost of permanent full-time attendant kept overall, looking after the victim 6,000 per month for 36 months. That's not that is not what my land.
Who has the receipt for this?
My lord, receipt is not available.
Who is the attendant?
That is also not being brought into the evidence, man.
Every piece of evidence has to be corroborated. If the father says, let's take for example this,
yes.
As far as attendant is concerned, if he says that he has appointed an attendant,
yes, ma'am.
Then this victim himself, the son, in his deposition should also say something about the attendant. Did he say anything?
Well, here in the chief he did not say
that during 36 months, somebody has attended to me.
No, there is no deposition by the victim.
How do we believe that there was an attendant?
Those were not challenged in the cross-examination. No question was put to the.
True, no question was put.
It was not disproved by the cross-examination. So the fact which has not been disproved by the cross-examination remains as proved, my lord. My humble submission. And in regard to the interest, my lord, what my learned friend has submitted. My lord, interest. There are various judgments, my lord. It depends upon the circumstances of the facts and of the circumstances of the case. It is not strictly that only that 1% can be. Even there is an instance by the Supreme Court also allowed 12% even. It depends upon the fact of the case and the discussion of the tribunal, my lord. So that cannot be taken as a.
You have authorities on that.
My lord, there are so many judgments are there. Only judgment 5 I can produce, my lord, but
Yes, you can do that.
today I'll in regard to the interest.
You see, all aspect of the matter. You see, if you are making, you see, certain assertion, certain contention,
my lord,
then you have to back it up by relevant authorities.
Exactly, my lord.
Issue of absence of relevant cross-examination, issue of attendance, why it was not so implicit as far as the evidence of the victim or the claimant or the father is concerned. All those things have to be backed by.
My lord.
Anything else?
My lord, that's my submission.
Just one very quick response, if Lordship allows. On the issue of disability, permanent disability, the contention of the claimant before this Honourable Court is that we have not challenged in our cross-examination, we have not challenged the fact of permanent disablement, my lord will kindly appreciate the burden of proof is initially on the claimant to prove the disability. The permanent disability has to be proved by way of cogent evidence, maybe a disability certificate. Only then can we challenge that certificate, that maybe it is a misleading certificate, it is a wrong certificate, etc. Without having proved their own case, they are seeking to rely on the absence of challenge that we have raised. There was nothing for us to challenge. If proof had been there for permanent disability, we could have challenged that proof. There was no proof for permanent disability. So to say that we have not cross-examined him on the aspect of permanent disability, there was nothing to cross-examine him over. That's all. That's all.
So, Mr. Nath, how long? You've cited, I mean, your authorities.
It's all there in the synopsis. It's all there.
Have you filed your written argument?
My lord, within few days, my lord, I may be allowed to submit some judgments, my lord. Only in the submission of the judgments. I'll give the copy.
You file your,
I'll compilation. I'll make a compilation.
You file your written argument. Annex your or attach your authorities. 1 week. 1 week.
1 week.
Heard Mr. General and Counsel for the appellant. Also heard Mr. H.R. Clark, General Counsel for the respondent number 1. Hearing is concluded. The appellant has filed the written argument, following which Mr. Nath has sought for some time to file this similar written synopsis of his argument within the next date fix. As prayed for, this is matter after 1 week.
Understood.